Good afternoon, everybody. It's Omar Serrata with the Tilted Lawyer podcast. So there's been a lot that's gone on since Friday when I was last live. Found out later that day that the complaint against Judge Mata that was filed by David Gingerbread was dismissed. Not only was it dismissed, but it was dismissed way back on January 17th. Why is that significant? Because like 2 weeks ago, our famous Gingerbread was saying this on a YouTube video that he had made. Let me just get out of that real quick and share this with you all. So 2 weeks ago, and this would have been about a month after the dated denial of the complaint against Judge Mata filed by David Gingras, he was off talking about this.
Phones. I didn't have the volume all the way up, and I just went back. And the part, Dave Neal, you were standing there, and Dave Neal's moved on. He's not making Laura videos anymore, so he won't even see this. But somebody came up to Dave Neal in the parking lot and said that they were sitting there with Judge Mata's dad talking to him. And you can't hear the audio of the woman speaking very well, but if you turn it up and wear headphones, I listened to it today and I heard something I'd never heard before, and it actually blew my mind. She said, and again, you have to interpret because you can't hear that clearly. I heard her say that she was sitting next to Judge Mata's dad in the overflow room, and that he was talking to her about the case, and that she said he had to watch his words carefully to not give anything away. And the way that she worded that, it made the hair on the back of my neck stand up, because it was the closest I think.
So that was that. He's carrying on talking about how shitty Judge Mata is and how corrupt the whole thing was. And he overheard something, and it made him shiver his timbers that people had to watch the way that they were talking in the whatever he was trying to say. So we know now that on January 17th, it was issued that it was an official denial of whatever he was on about. Let me just make sure that I'm not sharing the wrong thing. So there's this. Yeah, I don't want to share that. I want to share this all. And there's not a whole lot to share, honestly, because it is the policy of the state of Arizona that upon a denial, they're only going to show or publish the first 5 pages of the denial, whatever. Fine. It's just an order. It says the complainants alleged a Superior Court judge conducted an independent investigation and discussed a case with a family member. The role of the Commission on Judicial Conduct is to impartially determine whether a judicial officer has engaged in conduct that violates the Arizona Code of Judicial Conduct or Article 6.1 of the Arizona Constitution. There must be clear and convincing evidence of such a violation in order for the Commission to take disciplinary action against a judicial officer. The Commission has reviewed all relevant available information and concluded there was not clear and convincing evidence of ethical misconduct in this matter. The complaint is therefore dismissed, pursuant to Commission Rules 16A and 23A. Commission member Roger Barton didn't participate. Copies of this order or whatever. So these were the first 5 pages, and you can kind of see some of the arguments that Gingerbread was trying to make over the months since the June decision had come out. He tries to state, as explained in the attached notice of change of judge for cause, I have evidence which proves the trial judge assigned to this matter, honorable, redacted, we know who that is though, rules 2.9A, 2.9C of the Code of Judicial Conduct, among other rules. Specifically, there is clear and irrefutable, which is, by the way, a pay grade above clear and convincing. Clear and irrefutable proof showing that judge conducted an independent investigation into the facts of the case, and following a bench trial on blank, she issued a ruling filed in which some of her factual findings were not based on any evidence admitted at trial. Now, why is this important? On that Twitter post that I just shared, I had left an opinion that I kind of feel like David Gingerbread is the least credible licensed attorney practicing currently, certainly that I know. Whenever anything has come out of his mouth for the duration of his representation of Miss Owens, in conjunction with this case, and now more recently with the complaints against Judge Mata, he went after my friend Lauren Knighty. He went after Dave Neal. Now he's going after this appeal, and he keeps on trying to convince everybody that he's smarter than everybody. He knows all of the things that we're supposed to know because, well, for me specifically, I very famously had a rap battle with David Gingerbread. And in the course of that rap battle, I proceeded to ask questions about if what you're saying is true, then what are all these cases that's saying you're wrong? And then he said that I was dead to him, and I don't know what I'm talking about. I'm not an Arizona licensed attorney, which fair, I'm not. But I can research, and I have access to LexisNexis, which I assume is the same database that he goes for cases. Maybe he goes to Westlaw or some other bullshit. It doesn't matter. Case text, I don't know. But I have access to all of the cases in the state of Arizona, and I certainly know how to conduct legal research. And in the course of my legal research, I just said, okay, if what you're saying is true, then what about all these different things? I'm not going to rehash it here. To have a legal debate with him. It is an exercise of futility with a guy like that. And when he was, I feel like he got embarrassed because he just wasn't down. He didn't want the smoke. He didn't want it. At first, he wanted to come on my show and debate and do all these things. And when he found out that it wasn't going to go the way he was hoping, then he kind of backed out. And then the same thing, Reality Steve, who's like a bigger person in the YouTube. I don't even know if Reality Steve is a YouTube guy. I think he's just like a reality TV guy. He offered to have Gingerbread on his show and talk about some of the factual allegations against Owens. It never happened, and I suspect that's probably because it wasn't going to go his way. There's other attorneys and judges way more famous than I who have offered their opinions counter to what Gingerbread has argued in his appellate motions. And specifically with this Judge Mata stuff, how it was, in his opinion, so egregious judicial misconduct that it was the only equitable remedy would have been to overturn the judgment against her. That's basically what he was saying. We're like, okay, well, based off of what? Well, because her dad was there and because she made reference to one small thing that wasn't entered into evidence, that the only way she could have possibly known that is by conducting an independent investigation. And if she hadn't done that investigation, then she would have ruled in our favor, which is essentially what he was trying to argue. That was pretty much what the bar would have been for him to prevail in any of these motions. And I feel like really politely went back and said, yeah, I don't think, fair play. She referenced I think it was the hours of operation of a Planned Parenthood that Owens claimed to have been at that she couldn't have been at or something like that. I forget specifically what it was. But I said, yeah, fair play. That never came up in evidence. But was that so connected to the final judgment that we have to throw the whole thing out? No, I don't think it was, because that was like at the tail end of like 50 different things of why Judge Mata was ruling the way that she was going to rule. And yet he carries on, and I'm the idiot. And, Dave Neal is the idiot, and Lauren Knighty is the idiot, and all these other people, JFC Colt, and all these people, all of you guys don't know what you're talking about. You're going to be so sorry when this is over. And he's threatening lawsuits, and he's threatening defamation lawsuits, and he's subpoenaing Redditors and carrying on this way. And all of these things. And so now we just said, okay, fine. Look, I don't have any dogs in this fight, man. I'm not getting paid by Laura Owens to do this shit. I am simply an objective observer, as I've always been since I started covering this case. I want to say it was back in April of last year. Gosh, it's almost been a year. How time flies. But since I've got involved with this case, I have to say that David Gingerbread is the most oddball attorney that I've ever encountered take on a public case. And to the extent that he was ever to be taken seriously, he kind of shattered any auspice of that when, he made it a point prior to trial to start like having these YouTube comment battles or Twitter battles with online folks just looking for the truth. Bruce says, Omar's bars are like a lava lamp fire. These DSG's rhymes are like a cold flat tire. He'll ring the bell and declare a win. Omar has the crown and the appeal is in the bin. Mama spaghetti. I throw up over my on the Eminem song. I'm not a rapper. I'm not going to try to do the Eminem thing. All I'm saying is Gingerbread has had a propensity for making himself look like a fool throughout this case. I haven't had to do anything. Look, I offered to do like legitimate legal discourse. Let's just talk about the cases. Let's examine some of the legal questions. I felt it might have been very beneficial for him to know that if he's relying on this premise that the invocation of a singular rule for sanctions somehow supersedes all other available avenues to sanctions doesn't seem legally cognizable. And what about all these other cases where it happened without incident or issue? And then he's like, no, you're dead to me. He basically told me to get F off. Okay. And then I made an appearance in his Christmas video where I got like coal in my stocking or something. So, long history with this guy. Going back to this. So these are some of the things. We don't get to see the whole thing. Maybe there's a time in the future where the entire complaint will be published. When that is, I have no idea. No idea. Maybe never. But we have this. This is kind of what he's trying to convince the panel of in this motion. So as explained, he has clear, irrefutable proof showing stuff. All right. So second, due to the extremely high-profile nature of this case, the trial was attended by at least 100 spectators. As explained in the affidavit submitted in support of my notice of change of judge, after the trial, many spectators reported on video that judge the trial and at least one participant claimed that blank told them he had discussed the facts of this case with blank. And this individual claimed again on video that blank told him judge printed out documents from this case and shared them with me. What documents would have been really important, because I feel like everybody and anybody who was interested in this case whatsoever had all the documents with this case. I mean, these things are public record. You can just go and download them. Any of you watching this right now can go to the website and download these documents without issue. Not only that, but they're all over the internet. You could just find them. I don't even think you have to go to the courthouse websites anymore. Upon hearing this information recorded on video in the parking lot after the trial, one spectator urged others not to repeat these comments because blank. Based on this information, I have filed a notice for change of judge for cause, and I will be filing additional motions seeking to vacate and stuff. My client has been extremely traumatized by these events and by Judge callous disregard for her rights. Blank will agree to provide any additional information. Okay. And then there wasn't much more information. Well, that we can see anyway. This is a form. This is, I guess, the beginning of his motion that he filed. Case summary, background, and stuff. Professional pregnancy test, 5 pregnancy tests, the stuff that we've already seen. And then they just, there's nothing here to say. They just said, it's not enough. Sorry, guy. Judge Mata has been exonerated. Whatever you're claiming is wrong. But if you hear Gingerbread say it, I mean, I listened to it headphones, and what I heard, I could not believe my ears. The hairs on the back of my neck stood up on end. As I also mentioned in the comments on that Twitter post, the guy talks in clickbait, like all of these. He has these sensationalist sentences that he likes to spout out. And I could not believe this is the most egregious legal fallacy I've ever seen, I've ever run into. This is bullshit. We must remove Judge Mata. We will prevail on appeal. You see, the problem is when all of those things don't come to fruition, at every single juncture. Look, Gingerbread is a guy. He's had a long career. You don't have to be a good attorney to have a long career. You don't even have to be a good attorney to have a high-profile case. Because the truth is that Owens, before she ran into David Gingerbread, had scores of other attorneys who had evaluated the facts in her case and decided that they couldn't stick on. They couldn't represent her. There was one attorney, at least on one occasion, that had to basically write a addendum to the court. Hey, just so you know, at the time when I wrote these things, I didn't know that these other things were the case. Basically just trying to say, I wasn't trying to suborn perjury, which would be something where you could lose your license off of. Any reasonable attorney would have approached the case differently than David Gingras. And now you have a guy who is really, really, I don't know. It appears to me that the guy is starving for attention. He really wants to be famous. And whatever little fame and notoriety came out of representing Laura Owens, he was ready to just run with it. And he bathed in it. And it didn't matter if it was negative, good or bad. He just liked the attention. But at every juncture, he said he was going to win the trial. He lost the trial. He said he was going to get the Judge Mata removed. He failed doing that. He files his complaint against Judge Mata, and it doesn't work out. He's filing this appeal. Everybody that I've spoken with, now he has claimed that there's two other nationally renowned attorneys that have looked at it and came to the same conclusion he has. Great. I don't know who they are. I've never heard. And hey, maybe they know something that all these other attorneys don't know, but everybody else seems to think that he's due for a loss in this appeal. I gave a whole analysis of his appeal with my friend Steven, the lawyer. Maybe when the actual results come out, we'll cover that again. But until then, there's not really been much to talk about other than dunking on Gingras for failing to get Judge Mata removed like he said he would. He said he had clear and irrefutable evidence. At some point, this is what I know about law. And you see this a lot in some of the other cases that I'm covering. I mean, credibility is everything. If people know you to be a liar, they're not going to trust you. And in a business where it is your job to persuade the finders of fact that you are the one to trust and be truthful, every single time you open your mouth, it's a lie, and a verifiable lie at that. And every time you try to say you're going to deliver results and you fail to deliver, your reputation is going to take a hit. Now, look, I don't know. I know that there is a lot of noise going on around David Gingras behind the scenes. Not so much with this case anymore because the case is kind of over. We're just kind of waiting on the results. But I mean, there were bar complaints after bar complaint filed against the guy. Judge Mata herself filed a bar complaint against him. I don't know what happened with that. There were, I don't know who all the individual people were, but there were complaints stacked upon complaints complaining about the conduct of David Gingras. Now, it's okay. You're allowed to be a dick to anybody that's not your client or whatever, but it is not common for a legal community. And over there in Arizona, you have a legal community to kind of just pause and take note that what is this effing guy up to? That's not a common thing. I don't think I've ever heard of any singular case of a judge filing a bar complaint against an attorney. I know they can do that. I know they can. I know they're required to let the bar association know about if certain things happen. Like, for example, if an attorney gets convicted of a felony, then I think that they have to alert the bar that, hey, this guy's an attorney and I just convicted him of a felony. And just so you know, also the attorney's supposed to self-report in that instance. And so, I think that people are looking at Gingerbread sideways because he's not a trustworthy man. In a case that started out as, oh, look at all the bad things that Laura Owens has done. People still have that tenor to it. But now the fascination, I don't know, maybe it's genius on his part to just act so ludicrously to take all of the negative attention off of his client and put it right on his shoulders. If that was his intent, then I guess you've done the job. Because, I think that at this point, and I've certainly made the opinion on multiple occasions, I think that Laura Owens is in trouble with this guy. I think that he is preying on her need to be believed, and he's selling her bridges over Madison County, and she's like, hell yeah, and take my money, and he's rolling with it, and he's filing these appeals that to me appear to have no legal merit. Maybe they do. I mean, maybe there's small arguments made about certain issues here and then that would overturn a judgment. Not that I've seen, not that anybody else has seen either. And if I'm wrong, I would be the first. Hey, well, fuck, I didn't know. I didn't think it was going to work out. Turns out it did. Turns out some other legal theory was more important than other legal theories. And that's usually the way that works. I've been wrong before, but I'm also not here claiming to be the soothsayer, all knowing of all legal decisions and determinations. And I think if he were to probably talk to Gingerbread, he'd probably tell you that. The problem is he presents himself a certain way to certain people, and he's a used car salesman, man. What do they do when you walk into the used car salesman lot or a car salesman in general? What do they do? Oh, how are you doing, Mr. and Mrs. Smith? It's such a pleasure to meet you. That is such a lovely suit that you're wearing. Oh, I can't, man, you must have scoured the earth. I got to tell you, man, that really makes you look like aces over there. Let me tell you, what are you looking for? Oh, I'm just thinking I'm going to get this family car. Oh, I can see you want to get that car. That's fine. You can take that car, but man, I think I got the perfect thing for you. Now look, forget about budget. Just imagine you're going to sit in this car and imagine you taking your wife and your children in this car, and they start doing the full court press, and they start ingratiating themselves to you and playing on what they perceive to be your emotional weaknesses because they're trying to get them to like you. And as soon as they're in, and as soon as you guys are friends, then it's easier for them to convince you to do stupid things like buy a car that you can't afford. Oh, don't worry about a 12% APR rate. Oh, don't worry about that. What's more important, your money or your kid's safety? Let me tell you something. If you were to get in a car accident and you were in a lesser car and something were to happen to your children, would you rather have the APR or your money? All right, I'll bring the contract right over. We'll get this signed right away. Right away. I feel like the way that he's representing Owens, just from what I've observed in the snippets of YouTube videos where they're both on stream together, he does a really good job of telling her what she wants to hear. But I don't know, and I don't know meanderings of what they talk about back and forth behind the scenes. But it just feels like he gives her false hope. And for what cost? I wonder, I really am so curious about how much he's charging her for this. Now, he might tell you, oh, I'm not charging her anything. Oh, maybe not. I don't know. If he were to tell me that and the reason behind it was because he's trying to gain the notoriety and he likes the fame or whatever, then fine. Maybe that's a thing. Maybe. He's doing it all for publicity. But to the extent that you're jeopardizing your license, like there's a really good chance that I think that this guy is going to be disciplined by the state bar when all these things are said and done. At some point when they conclude their investigation into whatever it is that they're looking at, they may either suspend or revoke his license for a period of time, maybe not permanently. I don't know. But I would not be comfortable doing the things that he's doing in public. I don't know any other attorneys that would do the same. And he's placed himself in this position. To what effect? I don't know. But this is another example of David Gingras taking an L. Now, if you ask him, say, whatever. Whatever to that, they don't know what they're talking about. And you know what? I'm just going to file another one. I'll just file another complaint. How about that? I bet you'd probably say something like that. He's never going to admit to defeat. He will never admit to defeat, no matter how final the judgment is. And if he somehow comes to pass that the judgment against him stands because his appeal fails, he's going to say that the appellate panel was wrong. He's going to try to bring it to the Supreme Court. I don't think this is getting heard by the Supreme Court, but that effing guy is going to try. I bet you. Oh, anyway. Tiffany says it doesn't matter if they win the appeal because we already know what she's done. There's nothing she can do to change her past. She has to take accountability and work on herself. I mean, that would be the advisable thing to do. The advisable thing to do, if I was representing her, would be, look, you could file the appeal. I don't see much merit to it. But, if I was creative enough, maybe I can make like a Rule 26 argument, like David Gingras tried to do, not understanding the differences between civil sanctions and family law sanctions and, whatever. But yeah, and I've heard him say it, but not until after the appeal is over, before he milks another $50,000 out of her, or maybe more realistically, her family. I don't know. There's a lot of attorneys that do that. They say, look, there's a chance you could win, but it's going to cost you another $50,000. I could do this motion to vacate your criminal plea. And you know what we're going to base it on? We're going to base it on the fact that you're a Spanish speaker and they gave you the plea in English. Okay, that's what we're going to do. Fine. Yeah, and they'll convince them, look, if you don't do this, if there's no other chance you're going to get deported, so this is your last chance. They know good and well that it's going to get denied. Why? Because there's an interpreter there present, and it says so in the minute order. Not only did they give it to them in Spanish, they wrote it in English, and then they interpreted it in Spanish, and they had it certified on the record, and it was under oath, and it was in their native language. So this idea that they didn't understand what they were doing because it was written in a different language is defeated, because you have a Spanish speaker literally in their ear interpreting every word, and it's certified and all these kinds of things. No, they would know that and charge them $50,000 anyway and go after the motion and lose and take their money and sleep like a baby, vacationing on an island in Barbados or something. I don't know. I've seen attorneys do it. It's disgusting. It's the reason why I decided, when I was a very young attorney, like maybe 1 or 2 years in, I was forced to do some immigration cases, which was just, if you're unfamiliar, it's like there's no winning those cases. Like they have things that they can say to try to stay in the country, but they don't have a legal basis. They're going to get deported. Then you got to be the one to tell their family that their loved ones are getting deported. And it just got really depressing really fast. But I've seen fast talking immigration attorneys try to talk prospective clients that they know have no shot in hell and staying in the country legally, and they'll say, yeah, we'll give it a shot for $50,000 or $100,000 or whatever they charge, and they pay it, because what else are they going to do? And then when they lose, they get deported anyway, so they can't even make bar complaints about it, or they can, but what's the use of that? Lots of shady attorneys out there. Gingerbread appears to me, in my opinion, to be one of them. But hey, at least he was on Dr. Phil once, or whatever he was planning. He says that he wants to retire in a couple years. Maybe that's the reason why he's just like going scorched earth on the legal field. And if that's the case, I guess I kind of respect it. Good for you, man. Scorch the earth, get suspended, and then go F off to Europe. You're their problem now. And then go live amongst the ruins. Go take in all of the sites and the museums and whatever, and do whatever you got to do. Just leave innocent people alone. Maybe. We'll see. Mojo says, after Trump, the European will think twice letting such a person in. I don't know. I don't know what Europe thinks about a guy like that. I'd imagine they take him. Anyway, that's what's going on with David Gingras. I have a couple of other things to get to. Have you guys heard about this Delta crash? Delta now facing lawsuits over the Toronto plane crash. Apparently, they're trying to offer passengers $30,000 as a settlement. You know what this reminds me of? This comes from an article with the New York Post. Let me share this with you guys. We're done talking about gingerbread, by the way. I have other things for my full podcast. This is being recorded for my podcast. So if you guys want to bounce because we're not talking about Gingras no more, that's cool. But I got other things to talk about. And so this is one of them. This is the Delta case from the New York Post. There's an article that says their seemingly generous offer may have flopped. Now, a $30,000 offer to individual passengers in a crash like that is not generous. That's insulting. I mean, if you want to know a good parallel to that, I don't know if any of you guys are watching Landman, I think it was, or Billy Bob. And not to spoil anything, but there's a similar kind of thing that happens, which was this accident that occurs where people are injured or killed, and they're trying to get ahead of a lawsuit. And so they offer them settlement money, and they start off with like, here, we'll give you each $100,000 or $500,000 or whatever the number was. But it was embarrassingly low, because they know that if this were to go to lawsuit and they were to find out some things that they failed to do that were designed to keep passengers safe that led to this accident, then it's not $30,000 per passenger that they're going to be paying out. It might be something like $50 million per passenger. So you all do the math. More lawsuits in this case are expected to follow. Yeah, no shit. Delta would pay out $2.3 million if all 76 passengers, $2.3 million? Shit. If all 76 passengers on the airline subsidiary Endeavor's Airs CRJ 900 accepted the deal. That's not going to happen. But a man from Texas who filed one of the two lawsuits says he deserves more. $30,000. That's not even a down payment on a house nowadays. What are you going to do with $30,000? Here's $30,000 for your dead son, for your dead wife, for your dead whoever, mother, father, grandfather, family member, loved one. best friend. $30,000? You killed my loved one and I get $30,000 and I'm just supposed to just be okay and walk away? What would be the dollar figure that you guys would place on your loved ones? If one of your loved ones was involved in an accident that would have been readily prevented, but for some negligent mishandling of safety protocol, and all of a sudden the company's over to you, say, look, sorry for your loss, here's $30,000. Would that make you feel a little bit upset, icky, maybe? Now, I venture to guess that all 76 of these passengers were not seeing dollar signs immediately after the accident. Some of them, sure, for sure were, but not all of them. But now you insult them with a $30,000 per passenger offer like that? Mm, now I'm pissed. And now this is how you get 76 individuals involved in a class action lawsuit and potentially additional plaintiffs to punish Delta Airlines so that nobody will ever do this again. $2.3 million, try $2.3 billion. Now, I don't think they're going to get that much, but they want them to feel it. They want them to feel the sting of what lawsuits are designed to make you feel, which is financially in the pockets. Otherwise, are they going to cure plane crashes with this lawsuit? Of course not. But that's the game that's being played right now. So this guy thinks he deserves more. That passenger said in the lawsuit that because he was suspended upside down and drenched with jet fuel, he suffered severe emotional distress and mental anguish, as well as significant injuries to his head, neck, back, knees, face. God, whenever I fly, I get nervous when there's a little bit of turbulence on the plane. I can't imagine being hung upside down. A second lawsuit filed on behalf of a woman passenger from Minneapolis claims she is suffering from extreme bodily and mental injuries. The lawsuit also contends that the flight crew failed to observe the most fundamental procedures for a landing approach into the airport. Because of the Montreal Convention and international treaty that governs how airlines are liable for passenger injuries, baggage damage, and cargo loss, more lawsuits are probably in the pipeline. No shit. According to the treaty, passengers injured on international flights can be compensated up to $200,000, but it could be more if the airline is found to be negligent, and that's going to be where the fight lands. I mean, negligence in the pre-flight procedures, negligence in the in-flight procedures, negligence in failing to obey in-flight instructions. There's a lot of places where you could find negligence. This ain't over by a long shot. This is going to be going on for a while. It says passengers have 2 years to file a lawsuit under the treaty. 21 people were taken to the hospital after the crash and stuff. So that's what's going on with the Delta stuff. I don't think that, well, here's what I think. I think there's going to be a settlement with Delta. It's not going to be for 2.3 million. I'd imagine they're probably going to get up to 400 to 600 million before they settle that lawsuit, because I genuinely think if they take that to trial, and I don't know if there's caps on tortious claims over there in Canada or not, like there are in the United States, but I'd imagine they're going to be going for north of 10 figures over there. $1 billion. Punitives. Now, do I think they're going to get that much? No. But the cost of litigation, the bad publicity, this is going to get kept under wraps. It's going to hurt their pocketbooks no matter what. So 400 million, 500 million, 600 million, somewhere around that. Write the check, be done with it, and move on. I feel like that's going to happen. Maybe, and when it does happen, there's going to be a small headline and nobody else is going to be any of the wiser. Well, that's what's going on with the Delta case. By the way, a lot of you guys are wondering what Dominic has been up to. He's not been here in studio for a while. He's working more behind the scenes on the audio podcast. If you're unfamiliar or unaware, the audio podcast, Tilted Lawyer Podcast, is found on Spotify, Apple Podcasts, wherever you get your podcasts, really. It's there. We post our shows. This recording was supposed to happen last night. Didn't happen because my children were, they're being 4 and 5 years old. Refused to go to bed, and so we were just going to do it today. But he's working behind the scenes on content issues and getting the podcast and these YouTube videos up and published. And so he's still around. He's just doing other stuff. So that was that. Have you guys heard about this Detroit rapper that is suing Lyft because she wouldn't fit in the car because of her height. Now, I know that this happened like a week ago. Dominic wanted me to talk about it, and so I have. But what we have is Detroit rapper. She files a lawsuit against Lyft. She's alleging that one of his drivers canceled her ride because of weight. Now, when you have these Uber drivers, Lyft drivers, more often than not, they're independent contractors. So they're responsible for the safety of their passengers. And if they were to take on somebody that was morbidly obese or didn't fit properly in their seatbelt wouldn't fit, whatever, and something happens to them, they are personally going to be liable for the damages. So it was within this guy's best interest to not let her in the car, for one. I guess the name is Dajwa Blanding. Dajwa Blanding. I'm not familiar with her music, but that's her name. She sues the rideshare company and the driver, identified as John Doe, in Michigan Circuit Court for Wayne County on Monday, January 27th. And you know what? I'll share this with you guys if you are the reading type. Blanding, whose stage name is Dank Demos. Dank Demos. What does that even mean? Alleged that on January 18th, she contacted Lyft looking for transportation from her home to her cousin's house for a football game watch party. Doe arrives at Blanding's home around 10 to 15 minutes later. However, when she went to get inside Doe's vehicle, he allegedly refused to let her in. Court documents obtained by People say. Specifically, as plaintiff walked toward the vehicle, defendant John Doe locked the doors to his vehicle and attempted to drive away. A shocked Blanding then asks Doe why he tried to leave. He allegedly told her he wouldn't allow her in his vehicle because too big to fit in the back seat, and his tires were not capable of supporting plaintiff's weight. Now, at first glance, I don't know how much this lady weighs. I have no idea. If I were to put a guess on it, I'd say probably, well, I mean, I don't know how tall she is. And this isn't really a good picture to tell how much. I would guess she probably weighs 220, 240. It really depends on her height, doesn't it? If she's like 5'1", I could see where she would maybe only weigh 215, 220. But if she's like, well, I have no idea. I'm speculating. Point is, the guy didn't put her on a scale either, so he was speculating himself. Doe allegedly told Blanding that he had this problem in the past, adding that overweight individuals must order Lyft XLs. Lyft XLs are larger vehicles that can lift up to 6 passengers and cost more than standard rides, according to the company's website. Doe canceled Blanding's ride, left. Lawsuit alleges Blanding was unable to attend her cousin's party. Those are the damages, I guess. Maybe some emotional distress for being... Does she drop the term fat shamed in here in this lawsuit anywhere? She's accusing Lyft and Doe of allegedly subjecting her to a hostile environment and disparate treatment. Her attorney says, under the law, refusing someone transportation due to their weight is no different than refusing someone transportation based on their weight, their race, or religion. Discrimination of any kind should never be tolerated in our society. That is a misstatement of the law. Nowhere in the Constitution does it say that you can't be discriminated against because of your weight. Matter of fact, I'll pull up the specific, what he's talking about. Discriminate on the basis of race, sex, gender. He's talking about the Title VII Civil Rights Act of 1964 that prohibits discrimination in hiring, promotion, discharge, pay, fringe benefits, job training, classification, referral, and other aspects of employment on the basis of race, color, religion, sex, or national origin. The question is whether or not heavy-set people are a protected class of individuals, such as has been identified by the U.S. Supreme Court on the basis of race, color, religion, sex, or national origin. Nowhere in the Supreme Court has there ever been a case that I've read that says that you are protected because you are over a set amount of weight. So when he says that, it's a legal misnomer. It's factually, fundamentally, per se, prima facie, incorrect. Now, are they trying to probably extend protections? Of course they are. They've been trying that since 1964. Protected classes of people. Who are the protected classes of people in America? Just a basic Google search. And if you do that, you're going to come up with something like, in the United States, federal law protects individuals from discrimination or harassment based on 9 protected classes. Race, color, religion, sex, which includes sexual orientation and gender identity, national origin, age, disability, genetic information, and in some cases, marital status. But physical appearance on the basis of weight is not within those classes. Not. Now, they worked really hard to get those other 4 into there. Disability, genetic information, marital status was one, ageism became a thing. It's basically stuff that you can't guard against. Like, you have no ability to pick your gender or your race or your, well, I guess you have a choice to pick your marital status, but once you're married, you're kind of locked in, right? If you're disabled, you didn't, I assume, choose to be disabled. Now, you could say what you want. Some people don't choose to be heavyset or not. Some people absolutely have medical conditions that prevent them from being able to keep weight off. But for the vast majority, I think the science dictates that there are things that you can do to be healthier. And there are certainly safety regulations in place in every facet of every industry in America that dictate that if you are above a certain height or weight, then you cannot safely travel in this vehicle. When you step on an elevator, they're rated for certain weights, like no more than 10 people in the elevator, not to exceed 2,000 pounds or something like that, for a reason, because of physics, because of things. If you're so obese that you can't fit a seatbelt on you, and if you're legitimately, it's in a compact car and you're placing the car in danger of like busting a spring or throwing the alignment out, possibly leading to a flat tire, that is not safe conditions. And he has no ability. If he said specifically, I can't let you in the car, you're too big or too heavy, whatever, my car can't handle it, that is per se not impermissible discrimination based on federal law. So he's going to have to do better than that. But this idea that weight, he says discrimination of any kind should never be tolerated. That's his opinion. That's not a statement of law, to be fair. But what does he say? Under the law, refusing someone transportation due to their weight is no different from refusing someone transportation. It is fundamentally different, dipshit. Who is this effing guy? John Marco? The hell is he talking about? That's that is insulting to people that fought for those constitutional protections way back in the. Do you know how long? You know how many decades people fought to get Title VII, 1964, the Civil Rights Act of 1964 passed? You know how many people died to get those civil protections in place? And for him to just shit on it and say, oh, there's no difference in the law now between discriminating on somebody's weight or somebody based on their race, religion, whatever. Get the F out of here, dude. No, I did. That is embarrassingly insulting. This guy's a creep. Straight up piece of shit. I don't know this guy. I don't know who he is, but he's a creep. That's embarrassing. He continues, refusing someone transportation based on their weight is not only illegal, but dangerous. Attorney Zach Runyon. Oh, this is, it threw me off. This is Attorney Zach Runyon. Imagine the consequences if Miss Blanding were unable to seek shelter after the driver left her stranded. This could have ended even worse than it did. She was at a home. She was at a residence. She wasn't stranded in the middle of nowhere. She wasn't in some abandoned alley somewhere. It wasn't like an obscene time of night. And he gave her another avenue. Look, you're going to have to call like an Uber XL or something. That's not the same. These attorneys are fucking jackballs. Blanding is suing for damages such as stress, humiliation, embarrassment, outrage, mental anguish, fear, mortification. That's not a, I don't think that's a viable cause of action, sir. As well as emotional, economic, and non-economic damages. She's also asking for attorney fees and costs. No, ask all you want. I guess this is their response. Lyft unequivocally condemns all forms of discrimination. We believe in a community where everyone is treated with equal respect and mutual kindness. Our community guidelines in terms of service explicitly prohibit harassment or discrimination. All right. So that was a whole lot to say nothing. But if you want my legal analysis of that, their attempt to extend protected classes of individuals to those who might be a little bit overweight and maybe unsafe to travel with in specific vehicles. And I'm not even granting the driver that she was unsafe to drive. I have no idea whether she was or not. I'm just saying if he felt that she was unsafe to travel, then he was under no obligation to go forward on that ride. He said, look, I can't, safety, call an Uber XL, and then left. Where do I think this is landing? I think that they're going to fight this until it gets dismissed, ultimately for failure to bring a cause of action that's going to hold. I think that this is probably going to end with a motion for summary judgment at some point when they identify the safety precautions for Uber for Lyft, I guess, that state that if a driver as a subcontractor feels that a passenger is unsafe to take in a ride, then you should not take them. Something like that. And given that that's not an outright discrimination on a protected class of individuals, I think it's going to be a quick motion for summary judgment. But you got these idiots, Zach Runyon and who's the other guy, John Marco, stating just blatantly stupid things. That's a bad one. That is a bad one. I mean, that's stuff law students study. Your first year of law school, you learn about who are the protected classes of individuals. There's 9. And they don't include heavy-set folks or overweight individuals, whatever label you want to associate with them. So that's the Lyft story. Moving on. So I don't know how many of you are federal workers or not. I have a sister-in-law that is one. But I'm going to share this article with you. Elon Musk sent out an email, and Donald Trump had commented on it, where he gave all federal workers 48 hours to explain what they did last week or face consequences. And failure to respond might have the effect of them terminating the position altogether. Now, to hear Donald Trump explain it, I think he basically said something like, it's a genius way to look. It turns out that there's a bunch of governmental positions that are accepting employment benefits and pay for which there's not actually a person working those jobs. And this would be a quick way to at least eliminate those positions. When you hear him say it like that, it kind of makes sense. But this is the story. This is out of Federal News Network. Hundreds of thousands of federal workers have been given little more than 48 hours to explain what they accomplished over the last week, sparking confusion across key agencies as billionaire Elon Musk expands his drive to slash the size of federal government. Musk, who serves as President Donald Trump's cost-cutting chief, telegraphed the extraordinary request Saturday on his social media network. He says, consistent with President Donald Trump's instructions, all federal employees will shortly receive an email requesting to understand what they got done last week. Musk posted on X, which he owns, a failure to respond will be taken as a resignation. I wonder if they're going to actually read the responses. I wonder if they gave guidelines about what a response, an acceptable response would entail. Because I would have just put like Monday, got to work on time, did my work, left on time. Tuesday, same thing. Wednesday, Thursday, Friday, whatever. Same thing. Did my job that I was positioned to do. And that would be that. Well, did you fuck around at work? Not at all. Not even for a single second. I was not a thief of company's time. I would never steal from the government. Not a single second. Nothing. I was on time for all of my my breaks and my lunches or whatever. I didn't browse the internet at all. I put my cell phone in my desk. I just wonder what kind of responses they're possibly going to get without direction. It's going to be all over the place, which leads me to believe that maybe if it was just designed to specifically ferret out positions to which we're paying for that are not manned by anybody, just to eliminate them right off the bat, that kind of is pretty smart. If they legitimately don't give a shit about what responses they get, so long as they get one, you know? Um, Shortly afterward, federal employees, including some judges, court staff, federal prison officials, received a 3-line email with this instruction. Please reply to this email with approximately 5 bullets of what you accomplished last week and CC your manager. Mm-hmm. The deadline to reply was listed as Monday at 11:59 p.m. Although the email did not include Musk's social media threat about those who failed to respond. Some agencies soon told employees that they did not have to comply if they received Musk's message. Interesting. The State Department will respond on behalf of the department. No employee is obligated to report their activities outside of their department chain of command. According to an email from Tibor Nagy, acting undersecretary for management, that was obtained by the AP. The latest unusual directive from Musk's team injects a new sense of chaos between beleaguered multiple agencies, including the National Weather Service, the State Department, and the federal court system, and senior officials worked to verify the message's authenticity. It is authentic. And as Trump verified, is authentic. Thousands of government employees have already been forced out of the federal workplace, either by being fired or offered a buyout. During the first months of Trump's administration, as the White House and Musk's so-called Department of Government Efficiency fired both new and career workers. You know, I don't know what to think about what Elon Musk and Donald Trump are up to. I don't know what to think about it. It's, look, I hope it all works out. I really do. But my worry is they're going to have State Department say, look, my employees are not going to respond. We are going to respond on their behalf. And then they're going to say, you know what? You did not follow my instruction. And in a ego-based pissing match, they're going to say, you know what? Your department is eliminated. I mean, they've done it already. They've done that already. They've already done things like that. Is that a good or a bad thing? I don't have to know, man. I really don't. That's what's going on. AFGE President Everett Kelly called the new order an example of Trump and Musk's utter disdain for federal employees and the critical services they provide to the American people. It is cruel and disrespectful to hundreds of thousands of veterans who are wearing their second uniform in the civil service to be forced to justify their job duties to this out-of-touch, privileged, unelected billionaire who has never performed one single hour of honest public service in his life. There's certainly a lot of things that I can say about Elon Musk, the richest man in the world. I'm not sure how I feel about the fact that he is so closely tied to the White House. There are a lot of people out there that are going to have feelings similar to that. I didn't elect that effing guy. I elected Donald Trump. What is it I hear that Elon Musk is running there with a 620-year-olds doing an audit of federal spending? On the one hand, there's some that hell yeah, long overdue. On the other hand, it's terrifying. What in the F are they up to? What if they're up to no good? Like, what if they don't have America's best interest at heart? You know, we don't know what we don't know. It's a scary thought. And then hilarious to me is still my favorite presidential clip in the White House ever, where Elon Musk is sitting there and he's got his kid running around. And then his kid is kind of whispering to Donald Trump, "My dad is the president. You're a bitch." And Donald Trump is like, oh, that was hilarious. I didn't make anything of that other than it was comical to me. But Jesus Christ. Imagine that your dad is like the richest guy in the world. What would that be like? What kind of character would you grow up with? What if your dad was the richest man in the world, and then no matter what you did in life, you just got, look, here's $100 million to piss away in a trust fund somewhere. You could have it when you're on your 19th birthday. I mean, how would you grow up? Like, for what reason would you have to work hard at anything? I don't know. Maybe he's taking the I heard that Warren Buffett doesn't give money to his kids. Or maybe that was the other guy, the Windows guy, Bill Gates. I don't remember. It doesn't matter. I'm just saying, rich folks got their own problems. That's all I'm going to say. In a message to employees on Saturday night, federal court officials instructed recipients not to respond. We understand that some judges and judiciary staff have received an email directing the recipient to reply with 5 accomplishments from the prior week. Please be advised that this email did not originate from the judiciary or the administrative office, and we suggest that no action be taken. Wouldn't that be a security breach? Didn't we spend like a whole 2 to 3 years and beyond excoriating Hillary Clinton about the way that she emails individuals within certain facets of government agencies? I don't know. I'm just thinking out loud. Thinking out loud. Within the past few hours, potentially someone was receiving an email titled, "What did you do?" Verify. Okay. Yeah. So that's that story. That's this story. I don't know, man. What do you folks think about that? How do y'all feel about Elon Musk and what he's up to? Wink says, you wouldn't work hard. Spoiled brats, probably, to say the least. Probably. Oh. You know what's hilarious? During Donald Trump's, I think it was his inauguration ceremony, his son, the giant, the 6'9" guy, we know him. Our first introduction to him was in 2016. He was just this sweet little looking 12-year-old kid. Looked like a sweet kid. I felt bad for him because his dad got shit on for 4 years. And I was wondering how hard that must have been on him. But then he comes up to George Biden, and there's I forgot where, I'm not corroborating that he said this. I'm just saying there's this lip reader that basically he walks up to Joe Biden, in the midst, Joe Biden puts his hand to shake his hand. And then he just kind of looks at him Joe Biden, you're a bitch. It's all going down. And then Joe Biden, his face just kind of dropped. And then his mom was hey, now we got to be nice. And then he just kind of stands there and takes his position with that face that he has, the Donald Trump face. Man. Oh boy. Bruce says his email is not consistent with my management best practices video series. No, it was not. The management practices czar, Bruce from Oregon, has his own idea of what of how to do what Elon Musk is trying to do, and it does not comport with Bruce's ideas, to say the least. Anyway, moving on from that, what else do I got here on my desk? What am I missing? I talked about that. We did the yeah. I guess I'm going to end with some Blake Lively stuff. There's subpoenas. There's these subpoenas that are going around, and I've heard that there's not a lot new that's going on with the Baldoni case that we haven't already dove into. I'm just going to share with you guys this article. What do I think? Where do I think this is all headed? I think that there is a real problem with the evidence. Not even with the allegation, not even with the evidence, with the allegations that Blake Lively has put forth in her amended complaints. You read through it, you get through the entire complaint, and then you get through her entire amended complaint. And, reading it as if everything were true and trying to give her the benefit of the doubt, and her trying to attach exhibits and pieces of evidence to the things that she's trying to prove. You look at it and it's okay, so what else? What else? And I guess the big cliffhanger is there are going to be other complaints from other women. So which signals oh, that's it from Lively. It was literally just the dance scene and the fat shaming and whatever else. That was it. That was it. Public perception has led. It started off, I feel where people were sympathetic to Lively because obviously she got to hit first. And then Baldoni comes out with this 168-page timeline and just documents all of this evidence and puts everything in a proper context and has his own claims. And he asked for $400 million in retorts. And I don't know who was advising Blake Lively. And to be fair, maybe her attorneys just listen to her story and is like, oh, okay, fine. Yeah, I'll file a lawsuit and we'll do our due diligence. And then in the course of doing their due diligence, that's the best that they could come up with. I gotta imagine, because sometimes you take cases and you got to believe what your clients are saying is true. And so they'll come in here and they'll say that, oh, I was abused and I was this and I was that and I'm the victim and I'm this, whatever. And then, all right, and you believe them and you let them write their declaration and you file that as a petition in court, and it becomes that's something that you got to prove. You never know how the evidence is going to come out, and then come to find out that there's a smoking gun evidence, like there is a video of the purported incident that shows that your client was actually the aggressor. That is a sobering moment, but it happens. And when that happens, what do? You probably settle. And so I think that this is a situation where they were expecting better evidence to back up Lively's claims, and it just hasn't come to pass. And I think that Baldoni has the upper hand. And, we're messing around with these subpoenas. And this, I guess, was the new thing. And I'll read this article from Yahoo Entertainment. They talked about on Tuesday, Lively alleged an amended complaint. We talked about the amended complaint. They talked about Leslie Sloan fighting to be removed from Baldoni's lawsuit. I don't think that that's going to work. But the latest developments were, excuse me, Lively's attorneys subpoenaing Baldoni's phone and internet records in an effort to expose the people, tactic, and methods. The problem with that is that they were overreaching in their request. You can't just get every single text message and phone call and from every phone record that exists for the past 3 years. It was a bit of an overreach. And so they're going to whittle that request down a little bit. Earlier this month, Lyman warned both sides, the judge, to stop litigating their case in the media, cautioning that he may move up the trial, which is currently set for March of 2026. That gives them about a year to conduct discovery. They launched a new website, denying claims both parties seek. Yeah. That's not what I was looking for. Oh, this is the one. I apologize. I brought up the wrong article. I'm sorry, folks. I was looking for the one about the subpoenas, and I think it was this one. Yeah. So Blake Lively requests additional protections. And Lauren Knighty, she covered this on her stream. I'm pretty sure Dave Neal also did. A bunch of other people. But I learned about this initially from Lauren Knighty's channel. I forgot what she calls her channel now. What is her new, the Court of Public Opinion or something like that? Is Lauren Knighty the Court of Public Opinion? By the way, go check her channel out. We need to get her to 10,000 subscribers. She's like at 9.5. She's so close to 10,000. She's going to be so happy when she hits 10,000. If you all haven't already done so, go visit Lauren Knighty. I think she's now calling her show the Court of Public Opinion. The Court of Random Opinion. The Court of Random Opinion. That's what it was. Go check her out. She's working really hard to get her YouTube numbers up and new subscribers. And she's been covering this case. She's doing a really, really good job. Go check her out. The Court of Random Opinion. I like that name even better. Anyway, with this article, they talk about the subpoenas. Blake Lively requests additional protections. As after both sides agrees to a protective order, attorneys for the actress and her husband submits a letter to the judge requesting a stronger protective order than the court's model one. Among their requests for the proposed PO, which they also filed in a separate document, are an attorney's eyes only category, which applies to confidential discovery material of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is likely to cause a competitive business, commercial, financial, personal, or privacy injury. Lively and Reynolds' attorneys went on to claim that good cause exists for the court to adopt the proposed PO, citing the actress's recently filed amended complaint against Baldoni, stating, as detailed in Miss Lively's amended complaint, Miss Lively, her family, other members of the cast, various fact witnesses, and individuals that have spoken out publicly in support of Miss Lively have received violent, profane, sexist, and threatening communications. And Baldoni's team says, yeah, we have too. We do not condone dangerous, this is Baldoni's team, we do not condone dangerous rhetoric targeted towards anyone, no matter the situation. And said they too have faced threats during the legal dispute. They added anyone receiving violent messages by anonymous parties is abhorrent. When private parties were wrongfully accused by Lively and her paid team of wrongdoing, they received continuous death threats and visits to private home where young children reside. Yeah, that's sick. If you're the kind of person that will like send threatening letters or go to somebody's home, like look them up to go visit their home and like try to invade their private lives, you're just a sick individual. No one should have to face that, especially private parties who do not have the means for a security detail. Touche. So there's that. Whether or not there are going to be additional protections, I guess we'll see. They're working on it. They're trying to meet and confer to figure out what they're going to do in terms of what additional protections would mean. What does that mean for coverage? It just means that there is the potential that some of the subpoenas that are going to be conducted for depositions are not going to be publicized in an effort to protect potential witnesses. I think that the parties are probably fair game. Like if they ever subpoena Blake Lively, I think that's going to be fair to be published. Same with Baldoni, same with any of the other individual named parties. But if we're talking about some of these other complaints that were brought up to HR, specifically complaints made against Baldoni, if in fact they do exist, I don't think that we're going to learn of their identity until maybe never. Maybe never. But I think that those are reasonable protections to place for witnesses, prospective witnesses in this case, where I have heard it reasoned that this case might become bigger than Depp v. Heard. Why? I don't know, but maybe it might. And if that's the case, if you happen to be a witness, you're kind of signing up, or you're not signing up, but you're going to be subject to the eyes of the entire world bearing down and hanging on your every word. And that is a tough pill to swallow for some folks. Blake Lively, she's going to have to at some point be subpoenaed, and it's going to be public, I feel like. Ultimately, where does this land? I don't think for a second that this is going to make it to trial. I think that they're going to settle for some amount of money. I think Baldoni is going to want some amount of money. I think at some point, Lively's legal team is going to be like, look, the evidence is not going to do what you think it's going to do. And if this gets litigated, people are going to be pissed at you. And the punitive damages alone, they're asking for $400 million. They might get it. They might get that and some more. They may. If we try this and it goes wrong, and look, there's already instances of her changing her story. She started off with a complaint, and then she kind of softened some of the allegations and ditched some of the others altogether, which means that she's changed her story, which means that she's not in the credibility department, she's lacking, which means that if you're trying to pick somebody who to believe, who's telling the truth, it ain't going to be her. Baldoni has given his version of events, but backed it up with receipts, meaning he has ultimate credibility in this case, which was the genius of Brian Friedman's PR strategy. Look, I'm just going to drop all these receipts and let people see it for themselves, in conjunction with the claims that Justin Baldoni was making and Heath and all these other people. And what it did was it kind of exposed the ridiculousness of the claims of Blake Lively. And where we stand now is, absent other evidence, if that's really all there is, she's in a lot of trouble. And it would be in her best interest to settle, write Justin a check for some undisclosed amount and move on with life, because at some point she's going to want to work in Hollywood again. And the best thing that could happen for her is to settle this case before it ever makes it to trial. I don't know if they're going to settle it before depositions. I doubt it. I think if I was Baldoni, I think if I was representing Baldoni, I'd want to beat her up a little bit in a deposition, because it would cause the settlement figure to rise. You saw what just happened in that deposition room. Imagine if I get you on cross-exam in front of all those people in the jury. Imagine. We're asking for 400 now, but by the time we get to trial, after I litigate this entire thing, I'm going to ask that jury for $1 billion. Am I going to get it? Probably not. But you're going to threaten that. And you're going to say, look, this is not going to go well for you. I'm going to make you hurt, and you're going to need to feel that. And so at some point, I suspect after they depose who they need to depose on Lively's side, I think that they are going to be open to settlement talks. And you're going to hear Lively's team talk real tough about, oh, we have the receipts and we're going to depose him and we look for depositions and all these kinds of things. The reality of it is that on the evidence scorecard, Blake Lively's team is grossly behind in terms of credibility, which is all that matters in a case like this. And at the end of the day, I think that if they were to litigate this with the evidence that we know is out there, and I know it's not finished, I know that, but just looking at my evidence scorecard, I feel like Baldoni is coming out ahead. And if he wins and he's asking for $400 million, I feel like he's going to get more than that. He might get 5, he might get 8, but I think he's getting more than $400 million if he prevails at trial. So what would be a good settlement figure? I don't know, man. I think I would start, if I was Lively's team, at $20 million. We'll give you $20 million. This compensates you well far and above what you were stood to make for the movie. And, we'll issue an apology. We'll say it was a big misunderstanding, and everybody could just kind of move on. Are they ever going to get to that point? I don't know. But if I was her attorney, I would be pressing her to get to that point, because I don't think that it's going to be healthy for her career moving forward to try to litigate this in such a public arena for any longer than we have to. Majo says, the tilt alert, do you think it is not too late? Too late for what? Too late to settle the case? It's never too late to settle a case. Until a judgment is rendered, it's never too late to settle a case. No, I don't think it's too late. I just think that they want to litigate a little bit. I mean, they're spending millions of dollars a month on this litigation. I'm not speculating, but I'd imagine it's somewhere north of $1 million a month to litigate this thing. Maybe around that number, probably. They want a pound of flesh, and they're going to get it. Yeah, no, I don't think it's too late to settle, Majo. They could settle at trial. They could literally go through a full-on trial, and while the jury is deliberating, decide they want to settle the case. They can do that. And so I don't think they're going to settle right now, but I think that they're going to settle it before March of next year for sure. I think that there's I would be shocked if this went to trial, to be honest with you. So we'll see. That's where we're at with the Lively case right now. If anything breaks, I'm certain that my friend Lauren Knighty is going to be all over it. I know a lot of you also follow Dave Neal. He's been covering this case like a champ over there as well. And that guy's channel has exploded. He went from like 75,000 subscribers. I think he's up to 125,000 now, just off the strength of this Lively case. He's the hardest working man in YouTube. And so if you haven't already, go check out some of his content, subscribe to his channel. And some of the others that are doing it. Diane says, whoops, I didn't realize I was behind, and C was answering on the Lyft case front. Oh, well, I don't know, Diane, if you're talking about settling the Lyft case, I don't know. I don't know what to make of your question at this point. But folks, that's all I got for you on today's edition of the Tilted Lawyer podcast. I will be doing another show later this evening, but it's going to be like around 9:30, 10 p.m. Pacific Standard Time. If you guys are up and up for it, and you want to share I don't know, maybe a glass of some red wine, perhaps a cigar. I got some cigars on deck for Bruce when and if he ever makes it down to California on his van tour of America, if he's still doing that. I got a good brand of whiskey, or I'll have a good brand of whiskey just for Bruce, and some cigars. But later tonight, I'm going to be doing another show for today version of the Tilted Lawyer podcast, and we will see you guys all then. Other than that, I love you all. Be safe out there. There's going to be some members only content at around 4 p.m. Pacific Standard Time, answering your legal questions, but that's going to be reserved only for members of the Tilted Lawyer podcast who have subscriptions to the YouTube channel, where you'll be able to see me answer your legal questions in real time, give my legal analysis of whatever your situation is. Other than that, folks, I love you all, and we will see you guys next time. Bye-bye.